The next problem we want to look at is from the Henry Wilma Abdo Flora Inc. problem from July 1990. This is an excellent problem in the sense that it tests a number of issues that we want to practice on. Beginning with line 7, it says all the following events occurred in California. So that's helpful because we know 760 right here says all property acquired while married and domiciled in California is community property unless the statute says otherwise. So all this happened in California. Line 9. Line 9 says, shortly after he graduated from college in 1957, Harry purchased a home for $40,000. Okay. 1957, bought a home for $40,000. You could actually do that in 1957. And he took title in his name. Naturally, he's not married, so he would take the title in his name alone. Harry's father gave him $10,000 down payment. Fine. He's still not married, so we really don't care. And Harry borrowed the balance of the purchase price on a note secured by a 30-year mortgage for the remainder. Okay? This is separate property down payment, separate property credit, titles in his name. It's really not a community property problem yet. Line 11. A month later, right after he bought the house, okay, so the house has not significantly increased in value during that month, and that's important. So a month later, Harry married Wilma and began to work for the ABDO Corporation. I don't know why the bar examiners didn't make that corporation more pronounceable. The Abdo Corporation, no idea what they had in mind there. Anyway, a month later he goes to work for this corporation. Now what you should be thinking at this point is, well, if he's going to go to work, well, we can just keep reading. Harry made all the mortgage payments from his earnings, and the house is now worth $500,000. This is a very traditional, easy to deal with marriage with more problems. Do it by the rule. You would say the house cost $40,000, and there was $30,000 remaining on the balance when he got married, and the entire $30,000 was paid from his ABDO earnings. Well, you point out that his ABDO earnings are community property. Don't just declare it, explained by the rule, section 760, why his earnings are community property. So since his earnings are community property and he paid off the house with community property, he paid $30,000 out of the $40,000. So 30 out of 40 is 3/4. So the community paid for 3/4 of the house. Community paid for 3/4 of the house. Whatever the house is worth now, the community owns 3/4 of it. Doesn't matter how much it's worth. It happens to be worth $500,000, and so the specific amount that the community is entitled to is 3/4 of $500,000. If the house is sold, remember that money, 3/4 of $500,000, gets divided half and half. Half to him and half to her. Now, so you see how to do that analysis. Line 15. A homemaker, until their children were grown, Wilma enrolled in a local public university. And in 1983, let me see now, she earned a professional credential in landscape architecture. Let's watch our time. They got married in 1957. And 1983 is now when we're 1983 is now, what, 16 years later? 26 years later. 26 years later. So they've been married a long time. Her tuition and other education expenses were paid by Harry from his earnings. Again, his earnings are community property, so basically the community paid for her. The community paid for her education. They are investing in her, and they are entitled to return. If they stay together for more than 10 years, then there is a presumption that the community has been adequately compensated, and she doesn't have to pay them back the education expenses. If they don't stay together for 10 years, presumption is that the community has not been adequately compensated, and the court might very well require return of some or all or part of the education expenses. I remember that in order for the community to be liable, that the education has to be a type which substantially increases the person's earning capacity. If the education is in order to engage in a hobby or something of that sort, that does not substantially increase the person's earning capacity, and therefore it doesn't work. Line 19. In 1984, now in 1984 they've been married 27 years. Using $50,000 inheritance from her father. Okay, now money inherited from her father we know is community property. And please understand, as we go through here and we talk about these issues and discuss the law, nobody out there, I hope, is foolish enough to think that you're supposed to read these sentence by sentence and then write a few paragraphs about that sentence, and then read the next sentence and write a few paragraphs about that sentence. Anybody who thinks that is not ready for the exam. But I'm sure you know better than that, but this is the way we dig out the issues, talk about the law, and then you organize your answer according to the way what you ask. But these facts as they come up in the exam give us an excellent opportunity to talk about the law as it would apply to those facts, to expand on the law, to talk about what if the facts were a little different, and so forth. So it's an excellent way where these facts serve as an example of the law, and that's what I'm trying to do. Otherwise, I could just lecture to you on the law without these kind of concrete examples, and it would not be as meaningful. Back to line 19. In 1984, using $50,000 of the inheritance money, which we know is their separate property, Wilma established a remarkably successful landscape business called Flora, Inc., Incorporated. Remarkably successful, okay? That means that she used $50,000 of separate property money and created this remarkably successful business. So the business is going to be worth a lot more than $50,000. And now that the business is going to be worth a lot more than $50,000, what are you going to do with that increase above the $50,000? The $50,000 is not in dispute. That is her separate property. She's entitled to get it back. Whether she puts it in the bank or invested in this corporation, she gets her $50,000 back. But if the Flora Inc. is now a lot more valuable, if it's a lot more valuable, and so that it's worth, say, $200,000, then the $50,000 is increased by $150,000. From 50 to 200 is a $150,000 increase. And the problem we're going to have is who gets that $150,000 increase. And what you're going to do is what we talked about before. You're going to say, what is the primary cause of this? Is it labor or capital? It's the only two choices you get. And so since this is a landscape business, obviously it's labor. You should do them both just so the bar examiners can get most points. But obviously you would choose the labor. And so the labor is the primary cause of the increase, where the product of the labor belongs to the community. And so all of that $150,000 increase goes to the community, but before you give that to the community, you got to pay her interest on her $50,000 that she invested. So what she's going to end up getting back out of my hypothetical $200,000 is she's going to get the original $50,000 that she put in, that always was hers. She's going to get the interest on it, so $50,000 plus interest for however many years this went on, and then the community is going to get the rest. So let's continue. We're now at line 20. Line 20. In 1990, let's see now. In 1990, the business has been going on 6 years. She started in 1984 and is now in 1990. So for 6 years, the community has been using her $50,000. So ultimately, she's going to get her $50,000 back with 6 years of interest. You didn't have to calculate it, just say it's 6 years of interest. In 1990, line 20, Wilma was offered $600,000 for Flora, even though the physical assets were worth only $50,000, and she rejected the offer. Well, we assume that this was a good faith offer, and that's what the business was really worth. And so at this point, the way you would divide up that $600,000 is she gets her $50,000 back plus interest for 6 years, and the community gets the rest. And you explain that in the way I just talked about, that the primary cause of the increase was her labor because of the nature of the business, and since the primary cause of the increase was her labor, then the product of her labor belongs to the community because 760 says so, and therefore the increase, the $50,000 she put in is now worth $550,000, but now worth $600,000. So there was a $550,000 increase over the $50,000 she started with. That $550,000 increase was primarily caused by community labor, and therefore the community gets the $550,000 minus interest that you have to pay her for 6 years' use of her money. Line 23. In 1990, Harry was permanently and totally disabled in a hunting accident. So Harry's her husband, and he's totally disabled. So he's going to get some money from this, presumably, from somebody. In satisfaction of his claim for personal injuries, he received a $400,000 settlement. Okay, well, we know about community estate personal injury damages. The $400,000 community estate personal injury damages is a funny kind of community property. It is community property because 781 says it's community property. 781 right here says that this stuff is community property. But it's a funny kind of community property that's going to get divided up a funny way upon dissolution. And over here, 2603, it tells you, in the 2603, it tells you how to, yeah, really, sorry about that. Here at 2603, it tells you how to divide this up in case of dissolution. So he received $400,000 for his personal injury, and if there is a dissolution now, what happens? The $400,000, it goes, all of the $400,000. First of all, you pay, if the community paid medical expenses and things of that sort. Well, first what it says is you give the entire $400,000 to the injured party, and that's to Harry. So he gets the $400,000 minus less what the interest of justice requires. And 2603 tells you what kind of factors to take into account in trying to do justice. Look at how long how long they were married, how long he was taken care of by the community. I don't mean money-wise. I just mean the physical aspect of taking care of a sick person or an injured person. You look at the financial circumstances of both of the parties. Are they young? Are they elderly? Is one of them going to have to leave the workforce without a pension? All those factors that are listed at 2603B. So take a look at those. And so the $400,000 goes to him less what the interest of justice requires. Well, it says here that he used, at line 24, he used the settlement money to purchase a portfolio of stock, which is now worth $600,000. Well, that's fine. The portfolio of stock is now worth more money, but it doesn't. It's worth more money. It's worth $600,000, and it has grown in value. There's no Van Camp and Pereira analysis required here because there's no labor on anyone's part. He just put the money there and waited. So there's no labor. Only capital. His capital, the $400,000, is the only thing that's at stake here, not any labor. So you don't have a Van Camp and Pereira issue. You also don't have a business that's being run. It's just a straight investment. So if he were trading on the stock market every day, and using a significant amount of his time to do these trades, then you might say he's putting some labor in. But if he was not doing that, then he is simply he's not doing that. He's simply investing the money and leaving it alone. So there's no Van Camp and Pereira problem. But now this property is worth $600,000. And that is, his portfolio is worth $600,000, and the entire $600,000 now is subject to the same consideration. That is, it all goes to him minus what the interest of justice requires. And you use those factors we talked about regarding the interest of justice. This brings us to line 27. Harry can no longer work at ABDO because of his disability. Okay. I wonder if he had retirement money in a retirement account someplace. They didn't say so, so we're not going to do that. He now receives ABDO disability benefits, which provide 2/3 of his monthly injury salary. Well, his disability benefits was 2/3 of his salary. The question of whether these disability benefits are wage replacement. And they tell us that he is now no longer able to work there, so this is not like paying him for a few months so that he can come back to work later on. This is a case where he is permanently disabled, and when he is permanently disabled, the money which he now receives is not wage replacement money. But it happens to be 2/3 of his pre-injury money. Goes on to say the disability payments will continue until 1995 when he turns 60. Now, 1995 when he turns 60, at that point he will receive his retirement benefits, which are 3/4, which is even a larger portion of his pre-injury monthly salary. Well, what you do in these cases is that his retirement benefits, you will use the time rule, and he worked there for the entire time that he worked there. He was married, and so all of the retirement benefits are community property because he was married the entire time that he worked there. So you don't have to use it. If you use the time rule, it's 100% zero. as opposed to some other time. So the time rule, he worked, all of the retirement benefits are community property. The disability benefits, which he's going to receive until 1995, that's for 5 years, he's going to receive these disability benefits. I don't quite know if that's wage replacement or not. If it's wage replacement, it's plain old community property. But that seems like, even if he's totally disabled in 1990 and gets 5 years of disability payments, that would all be community property because it's money acquired during marriage and it's not gift, bequest, advise, or descent. So it is community property. So the ABDO disability benefits, as long as they are together, is community property. But now this means that if they get, during this 5-year period, from 1990 to 1995, so his accident happened in 1990, and in 1995 he's going to turn 60 and get his retirement, and all the retirement is community property. But suppose they get dissolved during that period, from 1990 to 1995, if during that period, well, if they separate during that period, the wage replacement money that he was receiving, or whatever that money was that he was receiving, that is separate property, because it's not money that is being paid out of something that he earned while they were married. The disability pay is just basically wage replacement, which I think this is. And so if they separate, his wages would be his own separate property. So if they separate, this disability money is separate property. But if he and when he retires at 60, he will get retirement money, and that is all community property. Now the interesting thing about this is that if they get separated during that period, 1990 to 1995, if they get separated during that period, and then all of his income becomes his separate property. All of his income is his separate property. And she gets none of it. But once he retires, she gets half of the retirement pay, because that was money that was earned and put away during marriage. So if they separate, she gets none of his disability pay, and she gets half of the retirement. And she'd probably like to get her half of the retirement, but she can't make him reach age 60 any sooner. So what do you do in that case? During the period, in 1995 she'll be doing fine, so she'll get half the retirement. But if they part before that, he takes all of his separate property income with her. Well, what she's entitled to in that case, for example, suppose in 1993 they separated. Well, she's entitled to have his retirement account, if his retirement is vested, so that it's his and he can't go anywhere, she's entitled to have a present value placed on that retirement account. What's it worth right now? And she's entitled to half of that. And that's how that would work. Let's keep reading. Harry and Wilma have decided to obtain a dissolution of their marriage. How should the following things be dealt with? Number A, item A, the house. For the house, used marriage is more. Community owns 3/4 of the house. Each of them owns 1/2 of that 3/4. Plus, don't forget the part that he owns separately. Flora Inc. Well, Flora Inc. is under the Van Camp and Pereira rules. We think that her labor is the primary cause of the $550,000 increase, and therefore the community gets the $550,000 minus interest on her $50,000. So she gets the $50,000 she started out with plus interest on that, Now the interest on that, we're now at 1990, and so the interest was 6 years. So she gets her $50,000 plus 6 years of interest on the $50,000, and the rest of it is community property, and she gets half and he gets half of the rest of that. The corporate stock. Well, the corporate stocks for $600,000 in corporate stocks is money from his personal injury, and 2640B says give it all to him minus what the interest of justice requires. Give him a discussion about the interest of justice. The ABDO disability payments, those are wage replacements, and they are community property as long as they're married and living together. If they separate, during the separation it becomes his separate property. Now, if they separate in 1990, he will get, again, he'll get his wage replacement for 5 years and then his retirement income. She gets none of the wage replacement if they separate, but she's entitled to have the retirement account determined, its present value determined, and to receive a half of that. Even if she has to get it in payment, she's still entitled to half of it. Item 2, should any adjustment in distribution be made in order to reflect the cost and value of Wilma's education? And we know about that. Okay. And the answer is that her education obviously substantially increased her earning capacity, and now they didn't say the education was in 1983, and this is 1990 when they're getting divorced, and so they didn't stay together for 10 years. So there is a presumption that she did not, that the community has not been adequately compensated, because it's only been 7 years since she was educated. But here, she can rebut the presumption that the community has in fact been adequately educated. It's been adequately educated because they made it, adequately benefited because the community made a lot of money off of her education. So she shouldn't have to go back and pay for the education also. And that's how we would analyze this problem. Let's look at the next problem. The next problem is the next problem is the problem that we want to do, the one from July 94. If we look at the July 94 question, July 94, this is the two Tom, Susan, Comco, and XYZ Corporation problem. Let's take a look at that. In this problem, it says that in 1983, watch your years, Tom and Sue married in California. Okay, so apparently what they acquire is going to be while they are they are married and living together in California. Everything they own is community property unless there's a statute that says otherwise. They have resided continuously in California since that time. In 1986, Sue started CompuCo, a sole proprietorship. Now be careful, that sole proprietorship doesn't mean that she owns it alone. Sole proprietorship is just a form of business like partnership and sole proprietorship and a corporation or an unincorporated association. So sole proprietorship is a form of a business organization. It's not saying it's hers and he's got no claim on it. So we know that from years of experience, if H started a gasoline station as a sole proprietorship, it's still owned by the community. Anyway, line 8, the sole proprietorship sold computer equipment and she started it using community savings. So this business was started during marriage, therefore it is owned by, it was started during marriage, and therefore it is owned by the community. So it's a community-owned asset. No matter how much time she works there or how much time he doesn't work there, it was started during marriage with community property assets. It's a 100% community-owned business. Line 9. She devoted at least 6 days a week to this business during marriage. She did not draw a salary. Okay, still, even so, the salary would have been community property anyway. So if the salary she might have drawn goes back in the business, the whole thing is just community property. And instead she used the Compco profits to expand the business. That's fine. It's 100% community property. Tom performs no services at CompuCo. Doesn't matter. It's still all community property. Okay. Line 13. On Tom's birthday in 1990, watch our times here. This was 7 years later. They've been married for 7 years. And so it says, on Tom's birthday in 1990, Sue gave him a Picasso drawing, which she had purchased with $15,000 in community funds. Well, so she bought it for $15,000. I don't know if you can buy a Picasso for that anymore, but she bought it for $15,000, and she gave him the Picasso drawing. Well, she can give him it's bought with community property, so the Picasso drawing is owned by the community. But she can give him her half of the community, community interest if she wants, her half interest in the drawing if she wants to. And the problem is that if she wants to do that, she might need a writing to do it. And Section 852C is the one that deals with that. And you may recall that Section 852C says that, 852 says if you want to make a transmutation, you want to make a transmutation from your separate to her separate, or her separate to his separate, or their community to one of them, any kind of a transmutation you want to make, put it in writing. That's what 852 says. 852 says it's not valid if it's not in writing. But 852C carves out an exception. Something that kept coming to mind I forgot to bring up just a minute ago. I'm sorry about that. But in the Flora Inc. problem, we said that in that Flora Inc. problem, that Flora does not have to return the education expenses because she can rebut the presumption that the community has not been adequately compensated after 7 years, because she did extremely well and the community has been adequately compensated. And that's all very good. But I kept intending to mention to you that also Harry does not have to pay her support anymore. If she was uneducated and they're getting elderly now, that he would have had to pay her support. And now he won't have to pay her support because she's got plenty of money and income of her own. So there's two reasons why she doesn't have to pay back the education expenses. She saved him having to support her, and secondly, the community has benefited enormously from her education. I kept forgetting to mention one of those. Also, in the podiatry problem that we went over, I meant to mention it there and never said it. That is, the person who has become a podiatrist now is earning enough money so that her husband does not have to support her. And without the education, he may well have had to support her. And so her education has saved him the cost of having to support her after the dissolution. So she shouldn't have to pay back the education money also. Okay, getting back to this problem. We're talking about 852. 852C says if you want to make a transmutation, that do it in writing, but there's an exception. The exception says you don't have to do it in writing if it's a gift of clothing, wearing apparel, jewelry, or tangible items of a personal nature used primarily by the donee spouse and not substantial in value considering their circumstances. That's what 852C says, and obviously the painting it may or may not be subject to those rules. Line 14 says, Tom placed the drawing in his office where he was employed. And so, is this an effective gift? Well, there's no writing. And so if it's going to be an effective gift, it has to qualify under 852C. So does this gift qualify under 852C? Well, let's see. Is the painting, a painting is not clothing, wearing apparel, jewelry, it's not any of that. Is a painting a tangible item? Yes. Is it a tangible item of a personal nature? Answer, debatable. And is it used principally by the donee spouse? Yes, line 14 tells us Tom hung it in his office. And finally, is it substantial in value considering their economic circumstances? Well, I don't know. $15,000 to these people at this time. We don't know very much about their economic circumstances. We don't know the value of the house they occupy. We don't know how much money she makes in this Contico business, how much the business is worth. So we just don't know. So we can't fully answer the question. What you should do on the bar when this comes up is point out what the factor is that you don't have hardly any information on, and you look through the problem. I don't like, do not like to end these questions or answer a question by saying to the bar examiners, I'd like to answer your question, but I don't have enough information. Okay, that's a terrible way to answer a question. So try to milk what you can out of what we got here. The only thing I can see is that we don't know if the business was very successful or not. We're just not told. So what I would say is that if the business is very successful, or if Tom, is very successful, that $15,000 is perhaps not that significant to them, in which case it does not need to be in writing. And whereas if this is significant, it needs to be in writing, and it's not. I don't know what else you can say. Don't say I don't have enough information. Give them the two possibilities. Line 17. In 1993, Tom and Sue began having marital problems. Now this is 10 years after they got married. Tom moved his belongings from the home in May of 93. Okay, well in May of 93, Tom moves his belongings, it looks like they're separated at that time. And if they are separated, then his income is his separate property. The income that she makes from CompuCo is separate property. CompuCo is still community property. It needs to be divided between the two of them. But let's keep reading at line 18. Tom and Sue continued to see each other. However, and they were consulting a marriage counselor, and Tom sometimes spent the night with Sue. Well, that's not really living separate and apart. If people are spending the night together from time to time, the courts are pretty clear, that is not living separate and apart. How do you decide if people are living separate and apart? Well, the rule is that they're living separate and apart if they are physically living separated and that one of them has expressed to the other no intent to reunite. Living physically separated, no intent to reunite. Now, here they are living separated, but I don't know that anyone has said to the other one, I am not going to get back together with you. And so, given that they're seeing a marriage counselor and that Tom would spend the night there sometimes, that these people are not separated so far as the law is concerned, because they are not living separate and apart, where one of them has informed the other of no intent to reunite. So they're not really separated. But consider both possibilities in going through your analysis. Line 21. In July of 1993, Tom was severely injured in an automobile accident. Okay, so we see it coming. We see community estate, personal injury damages. Two places here it shows up. This just says it's community property, but this tells you what to do with it. 2603 and 2641. 2603 A and B. 2603 A and B tells you what to do with the community estate personal injury damages. So Tom has been injured in July. Now, so they separated. They tried to separate in May, but I don't think they did. And a couple months later, Tom gets injured. And now, if they are still married and living together, then the money that comes in from this injury is community property. If they are separated during that 2-month period, then the money coming in is Tom's separate property. Let's continue. Line 21. Tom incurred significant medical expenses, which were paid with community funds. Well, let's see. If they were still living together when the accident happened, the community paid his medical expenses, and then when he finally gets some money, the community is obligated to pay his medical expenses, whether he gets any money or not, if they were living together. And so when he finally gets some money, that money is community property, but if they go their separate ways, all of that personal injury money goes with the injured party, except as the interest of justice requires. And the interest of justice will require that Tom reimburse the community for the medical expenses that it paid, so long as Tom takes at least half of the money with him. Now, so continuing at line 22, in November 93, Tom settled a claim for $100,000. So that $100,000, if he was separated when the accident happened, that's his separate property, but if it's his separate property, he's still going to have to reimburse the community for medical expenses, because community property money was used to pay his medical expenses, and they are not obligated to pay his medical expenses, and so he has to give that back. If they were married and living together, then the community is obligated to pay the medical expenses, but he still has to reimburse them because the interest of justice requires it. Let me point out something at section 913 or 914. It says that you have to pay your spouse's necessities of life. And I want you to be aware that even if the two spouses are separated and there is no community property money at all, and they are separated but not divorced, and one of them incurs necessities of life, food, clothing, shelter, okay, then the other person can pay it, that you are required under 914 to provide the necessities of life for your spouse as long as that person is your spouse, even if you're living separate and apart. And normally, people don't get so destitute that you have to pay their basic food and shelter. Normally, when they're separated, one person has a job and their basic necessities are met. But if they're not, if they're hospitalized or something of that sort, there's an obligation to continue to pay for the necessities of life even while separated. Not while divorced, but while separated. So here, Tom got injured, and if he had no other way to pay his medical bills, the community she would be obligated to provide those necessities of life. But when he got the insurance settlement, he would have to reimburse her. Continuing, line 23. In December of 93, Tom and Sue concluded that their marriage could not be preserved and a dissolution action was commenced. So that is in December of 93. And I've got to watch this because Tom moved out in May. And if they were truly separated in May, I doubt that. If they were truly separated in May, then they were separated from May of 93 until December of 93. Okay, and that's 7 months. So during that 7-month period when they were separated, she no doubt continued to operate Compuco. She continued to operate Compuco. It's a community-owned business, but she's operating it. Now, when the divorce comes, the salary, if she gets collecting a fair salary, the salary that she gets from Compuco is her separate property. But Compuco itself was community property when they separated, and during the 7-month period of separation, if Compuco increased in value during that time, if it increased in value, who gets awarded that increase? And the rule is just as we've talked about before. You look to determine the primary cause of the increase. If the primary cause of the increase is labor, she provided the labor, so she gets all the increase. But you have to pay the community interest on its money. The community owns the business itself as it was valued in May of 93, and that whatever value you place on that business, she was using it from May to December. And so the community not only gets the business, it gets the interest on the value of the business during that period from May to December. And then that's what the community gets, and it gets that divided in half. That's assuming her labor was the primary cause of the increase. If the capital was the primary cause of the increase, if the business was big enough so that her personal labor wasn't that big a deal, And so if the capital is the primary cause of the increase, then the capital is the primary cause. You give all the increase that happened from May to December to whoever provided the capital. Well, the community owned the business, that's the capital, so you give all of that increase from May to December to the community. Okay, but before you give all that increase to the community, pay her fair wages because she was working there from May to December. And that's how you do that. So line 29, in the dissolution action, what are the rights upon ensue to the following? First of all, to Compuco. Well, Compuco is a community property business, and but it may have increased. It was in May, and well, let's do both. Suppose they were and were not separated from May to December. Let's do both of those. If they were not separated from May to December, then you just place a value on Compuco in December and divide it in half. It's easy. If they were separated from May to December, then you place a value on Compuco in May at the time of separation, and you apply the Van Camp and Pereira rules to the period from May to December. Item 2, the Picasso painting. Well, the Picasso painting, she tried to give it to him orally. The code says you need a writing, but the code has exceptions. So does the Picasso painting qualify under one of these exceptions? And it will qualify under 852C if it is a tangible, if the painting is a tangible item of a personal nature, which is used primarily by the donee spouse and not substantial in value considering their circumstances. And so you go through that analysis. And finally, item 3, the personal injury settlement. Well, the personal injury settlement was $100,000. If upon dissolution, if they were together when the accident happened, the $100,000 is community property. But even so, when he leaves, he's going to take the entire $100,000 with him, minus whatever the interest of justice requires, and that would be medical bills and maybe some other things. If they were not separated when the accident happened in July, then the money, the $100,000, is community. I'm sorry, that's what you do. If they were separated, pardon me, if they were separated in July when the accident happened, then they were living separate and apart when the accident happened, and the cause of action did not arise while they were married and living together. And therefore, the $100,000 is his separate property money, but he's still going to have to reimburse the community for his medical expenses. And that's how you would analyze this question. Let's take 10 and do the last question for the day.